the gap. We welcome our third presenter of this panel, Marcin Warchoł. He'll be speaking on the prescription of communist crimes. This will be in Polish, so if you need those, please put them up now. Please go ahead.
Good morning. Excuse me, first of all, for delaying, but I had small car accident owing to weather, bad conditions, but everything's good right now, so we can proceed to our subject. In Polish, yes? Okay. Zagadnienie przedawnienia.
The issue of prescription of communist crimes is closely related to the resolution of a Supreme Court from May 2010 in Poland, where the Supreme Court of Poland expressed their view that Article 4, Clause 1 of the law on the National Remembrance Act does not constitute a norm for the fixing of a deadline for prescription of communist crimes. So the thesis is not self-explanatory at all. So in order to illustrate the problem, let me refer to two cases, two instances which took place in the 1970s. On the 25th of May, 1967, the functionaries of communist time, the motorized people's militia, violated human rights by detaining the person who was arrested in the course of a strike. They kicked and they have beaten up the person, which led to injuries. This deed was classified as beating according to the law in 1976, and it was not persecuted by law. After 1989, legal framework for the persecution of beating or battering of an arrested person were finally laid down. In 1995, we had an amendment to the Polish criminal law. It entered into force in July, and it stated that all deeds that are punishable with imprisonment up to 5 years' time will start being effective as of 1st of January 1990. As a result of this, the deadline for their prescription would be 5 years. So they would cease to be effective on the 1st of January 1995. So the law, which entered into force in July 1995, acting backward, declares that certain deeds cannot be punishable anymore, and yet in the criminal code they would be punishable with 5 years of imprisonment. This includes battery, this includes assault, physical assault, and in this connection we have the following problem to encounter. Does the criminal code, which enters into force in 1998, can it restore this course of prescription? The basic question is whether we can restore anything. Something can be only restored if it existed and stopped to exist. And the deadline for statute of limitation or for prescription of most common offenses under communism, like battering, beating up of citizens, was 5 years' time, and yet this crime was never punished. So, in 1995, the Polish legislature stated that those crimes could only be criminally persecuted from 1990 to 1995. And yet, they were not persecuted at all. I just gave you one example of battery cases in 1976, which would be prescribed in 81. And then throughout the 1980s, this assault would be no longer punishable because it is subject to prescription. It is no longer treated as something to be persecuted because it was subject to prescription. And the year 1995 has not brought any changes in this respect. We have no legal basis to persecute such deeds. In 1995, if a prosecutor wanted to start an action against the culprits who were beating up their victim in 1976, the prosecutor would not be able to, because the deed would be deemed to be limited in time. So it was only the amendment to the criminal code from 1995 that opened new opportunities. Would those opportunities be really exploited? To my mind, no. This was a fiction. What about deeds and offenses that were punishable with 3 years of imprisonment? Well, those offenses that were perpetrated by the civil servants in the communist state were forgiven and were considered to be null and void. So there was no way to seek an illegal redress against anybody who committed a crime that was punishable up to 3 years of imprisonment. A legal question was formed in this context that was asked of the Supreme Court of Justice because we saw inconsistent jurisprudence. In the 1990s, some of the courts started to believe that back in 1997, when the new criminal code entered into force and the new law on the functioning of Institute of National Remembrance, by the same token, the deadline for prescription of such deeds of such offenses would be extended up to 30 years. So the legal basis was there. But the question was if we could restore something that was already terminated. Some of the courts believed that in such a circumstance, the act establishing the Institute of National Remembrance should be applied as the basis for punishing the culprits. Other judges believed otherwise. They decided that something was prescribed until 1995 and there was no way whatsoever to restore the time of prescription because if the legislator stated that something was prescribed, he cannot state later that it is not yet subject to prescription. So there was a legal controversy, and the legal question was asked of the Supreme Court of Justice. The Supreme Court of Justice, in its resolution of May 2010, expressed their view that the law on the National Remembrance Institute doesn't constitute an independent normative basis for the fixing of deadline for prescription of communist crimes, because such statute of limitation should be always fixed in the light of the amended criminal code as of July 1995. And now, to what extent the ruling of the Supreme Court of Justice impacts the judicial practice nowadays? A number of cases were suspended, the cases that were subject to initial proceeding in the Institute of National Remembrance. The cases were dropped, they were dismissed, and the court decided not to level any charges before the court, because the ruling of a Court of Justice is prevalent in this case. And even if the resolution by the Supreme Court is not binding on common courts of law, the prosecutors of the National Remembrance Institute decided to drop 181 cases after 2010, and yet those cases were investigating batteries, inhumane and degrading treatment of arrested people, harassment of arrested people, which was all punishable with the imprisonment up to 5 years' time. So battering, harassment, these are the grave crimes that were finally dropped. At the end of the day, the punishment in 246 cases was abstained from. I was investigating this case a year ago, and I found out that as many as 246 cases were dropped following the resolution of the Supreme Court in May 2010. And now, the main proposition in my paper is as follows. The Polish legislature in 1995, in practical terms, made it impossible to persecute the perpetrators from the communist era, and as a result of this, the victims of those crimes were deprived of any legal protection, which violates the provision of the right to justice articulated in Article 6 of European Convention of Human Rights. The victims could not seek any legal redress in the courts in order to have all the wrongdoing remedied. Very drastic cases too were involved. I was investigating those cases in detail. In one case, we saw the instance of battering a woman who was pregnant. So you can imagine the brutality of the offense. Can we nowadays, introduce a new law in Poland? Do we have any legal remedies to repair the situation as it stands now? To my mind, it seems to me that the only way out would be an attempt to present to the Constitutional Court in Poland the legal question about the constitutionality of Article 108 of a Polish law from July 1995. This is Article 108, Clause 2 of a criminal code, which was newly amended in July 1995. And the consolidated text was presented on the 12th of July 1995. So in the context of Article 41.1 of the Polish Constitution, which speaks about people's rights to courts, to have access to courts, and Article 44 of the Constitution, which speaks about prosecuting communist crime, we should have such a legal basis. Also, the constitutional rule about citizens' confidence in a state, which should be represented in such a legislation so as not to arrive at a situation where the law is a trap to a Polish citizen. Well, this is all a subject matter that should be investigated, scrutinized by the Constitutional Court. The law from 1995, was it a trap to Polish citizens, to victims, the ones who suffered from the wrongdoing? Would the law from 1995 duly respect people's rights? Would the law from 1995 be fair play, to use a colloquial term? In this connection, there are new opportunities arising to resort to the Constitutional Court. Other actions, other legislative initiatives are doomed to fail because we are moving in a vicious circle where there is a conflict between two laws from July 1995 and the Act of on the Institute of National Remembrance from 1998. And this is only down to interpretation which law would prevail over which. So the question whether the legislator could restore prescription, this is fully illegitimate because you can only restore something that existed and stopped to exist, whereas the deadline for prescription, the persecution of communist offenses was never started and therefore could never be subject to prescription. Thank you very much.